Thank you so much for taking time to tune in with us for this live webinar event hosted by ProVentures. You can visit us online at proventures.org to see our upcoming events on our calendar. And also, please follow us on LinkedIn if you have a LinkedIn profile. And Dr. Colby here today is our seasoned IP expert based in Silicon Valley, and he is passionate about helping entrepreneurs succeed. I would like to turn the stage over to Dr. Colby. Dr. Colby, please take it away.
Hey, Jennifer. It's a pleasure to be here today. So I'm going to talk today about patents in valuation and funding. And my goal here is to give you some information that's going to let you create more value for yourself and for your company, and how patents work in that scenario, how you can use IP in general to benefit yourself. But before I start with that, I'm going to kind of go over the question that one usually hears when you're talking about patent and valuation, right? So it's not, how do I use patents to get more value? People typically ask, what are my patents worth, right? And the answer that I always give is, its beauty is in the eyes of the beholder. So traditionally, I give, when people ask me that question, I say, well, it's like your significant other. Um, everybody's got the right person for them, and a perfect person in one person's eyes is a disaster in somebody else's eyes, right? We all know that. Unfortunately, uh, that's true. Otherwise, the world would be a really crazy place. But the analogy I think that works better in business is going back to monopoly. And hopefully most of you will recognize this as the cherished boardwalk card from the Monopoly board game. And my question is, what's that card worth? Right? Well, it really depends. The first question to ask is, what stage are you in the game? Right? What other properties do you own? Let's look at the full board. It depends. If you already own Garden and Ventnor Avenue, well, then Atlantic Avenue is going to be worth a lot more to you than Boardwalk if somebody else already owns Park Place. This is a really good analogy in intellectual property. The value of a specific asset is very highly dependent on what you are doing, what other people are doing, and what other assets you have. So, for example, if you have a patent that really fits your business model and is well mapped to your business plans, that's much more valuable than a patent that really is poorly connected to your business plan or covers something that's really not that important to your customers. And again, just like the monopoly board, somebody's got to land on your property to make any money out of it, right? To be of any value to you, it has to be something that becomes valuable later. So I'm not really going to answer, and it's very difficult to answer the question of what are my patents worth, right? There's a Because it depends on so many different things. How do the patents relate to your business? What kind of, you know, what are your competitors doing? Are they doing anything that relates to your patent? There's another question that we can ask that's much better, and that is actually much more useful for your business. And that question is, why is a early stage cash limited startup where I spent thousands of dollars on a patent portfolio? And the reason you're going to do that is not necessarily to bash the competition. The answer is valuation and funding. Right? My job as a patent attorney is to get you the best valuable possible for your company every time you raise money, and then finally on your exit. And the exit, most important, right? That's the chance you have actually to put money in your pocket. So the goal of a patent attorney is to make those numbers better for you, right? So instead of answering the question, what's my patent's worth? I'm going to answer the question, why should you do patents and how can you make your patent more valuable for you in the end and for your company and hopefully for your pocketbook, right? Okay, so let's dive in just a little bit here. First, you have to have a patent strategy. Okay, and we're going to talk about that a little bit more. You're going to want a strategy that ties to building valuation in the company, right? When you talk to your patent attorney, you should be telling your patent attorney should be asking, what is it that we should patent? Okay. How can I make patents more valuable? And I have seen cases where companies have exited in short order. I can think of one case, two founders, 11 months old company, some great IP filings. Those guys were about 20 years old and they each got $5 million, right? That was a good foundation. Of course, they've gone on to do even better things. I've seen situations where there's been bidding for a company, right? Or there's been more than one company in the same space, and there's one large acquirer ready to go buy them. And the one that had a better patent portfolio got bought for a lot, hundreds of millions of dollars. And the one that didn't quite have a good portfolio just went under, right? Got sold off to creditors. And a big difference was the patent portfolio. It wasn't, mind you, the only difference. In the case I'm thinking about, there was also a great CEO of the company that got bought. And part of his value was he was easy to work with. He was a nice guy. People wanted to work with. So that's an example of, you know, why companies get bought. But it was definitely part of the situation was the patent portfolio. Again, if I do my job right, every time you raise money, you have a possibility of getting a better valuation if you have a good patent portfolio. And in a few minutes, I'm going to show you how you can present that to investors. So now let's go back, focus a little bit more on exactly how you can make your strategy better so that your patent portfolio increases your valuation. All right. First item, the patent is for the marketing people, not the engineer. It's the engineer who's going to get their name on the patent, probably the inventor, but the real value to the sales and marketing team. So if you're the CEO of a startup, I want you to put your marketing and sales hat on first, right? Because you probably do a lot of different jobs. And I want you to think, okay, what is it that my customers really want? What is it that my salespeople are going to say to customers? They're going to say something like, we are the only one that has this, or you've got to buy our product because it has this, or everybody wants our product because it has this. That feature that is in there, that is what you want to have. Remember, patent is a monopoly on something, right? It gives you certain monopoly rights according to government law. That's what you want to be able to tell your customers, that you have a monopoly on that feature that they want. The patent strategy really has to be product, not the thing that the engineer thought was really cool, okay? But the thing that the sales and marketing people get really excited about. That's what you want in your patent. So the patent portfolio should be really tied to your product. If you're doing a lot of filings, there might be some ideas you have that aren't in products yet, but somewhere on your roadmap, you think, hey, this might be really valuable. We might go in that direction in 3 to 5 years. Okay, let's patent it now, right? Because you want to be first. The goal of, if you take this approach, when you're doing your B round and you're raising $25, $50 million, you're going to be talking to your investors and you're going to say, these are the things that may have made our company so successful, why we're growing 20% per month, why everybody's screaming, give us money and invest in our company, and why we're going to take your money at these great terms. Right? are going to present to investors. And you want to then talk about those features that have made your company so great. And you want to be able to say, hey, this is exactly what makes our, um, this is exactly what we have a patent coverage on. And if you take that kind of strategy as you develop your patent portfolio and you focus on valuation, end effect is that you will get better valuation because of the patent portfolio. And this is what I like to say. You want to make your IP more than just a checkbox. In other words, when your investors are doing due diligence on you, they've got a checklist there and they say, do they have an IP program? Yeah, check. Great. Well, everybody's got that. Right? What you want to do is have a portfolio of IP that you can show to the investor really relates to the value of your business. And that's what can get you a fantastic exit. That's the type of thing you want to do. Now, when my clients are doing these later rounds, right, it takes a little while, a few years to build up a patent portfolio and so on. But when they're doing their A and B round, I like to make a cluster map. And I didn't invent the cluster map. I'm going to show you one right now. Let's just show you this cluster map. I was kind of in a red pink mode when I did this. Okay. So this is an actual cluster map for a client. They've given me permission to show this around. It's pretty old now. I'm sure there's more patents on it. This is at least 5 years old. This client is in the image processing space. In other words, they can take images and put it through an AI engine and come up with really good tag describing what the image, understanding the image and describing in a full sentence what is inside the image. And their magic sauce had 4 elements: image prioritization, optimization of the process of the image processing, including optimization of quality and cost. All right. Being able to distribute the processing, in other words, having a lot of the processing done on client devices so that the client didn't have to bear the costs of expensive AI servers. And then being able to select specific object within an image for further processing. So those were the magic features that allowed them to really sell this business, right? This is why their customers were really excited. And they have a lot of big name customers. And one of the things about this company is they actually developed one of the best databases of images, something on the order of 750 million well-tagged image, one of the best, highest quality training sets out there right now for image processing. So in the pink are those super special features that they have, right? And while they're doing their later funding round, we went and produced, I think it was an A round, we produced this chart and it shows the relationship between those special features and many of their patent filings. And the idea here again is to make the IP portfolio more than just a checkbox. What my client would do is just, they would talk to the investors about how successful they've been and why they've been so successful. And then this slide would pop up and they would have just finished talking about these key features: image prioritization, object selection, etc. And then they would show this and the investor would go, ah, right. And in the mind of that investor, that IP portfolio just got enhanced and elevated to the point of, really, these are the reasons that our customers like our IP or like our product, and the IP portfolio is directly related to that. And there was actually a lot of money in this. Let me give you an example. In the middle here, there's an application entitled Image Directed Search. So this company could go through websites or social media and look at the images and get an idea of what the image was about and use that for search and for placing advertisements, for instance. They could get double-digit click rates on websites by really analyzing images posted on that website, which is really tremendous. I mean, fantastic results. Anyway, that's just an example. And by showing this slide, we really increase the value. Now, I've been talking a lot about patents, but I'm going to just stop here and remind you a bit. Oh, one thing. If you have any questions for me, please put it in the chat. I will go ahead and click on the chat when we're done. And let me click that right now. Yeah. And if you have any questions, I'm probably going to take another 10 or 15 minutes on the lecture. If you have any questions, please put them there and I will go through the chat at the end. All right, let's go on. Next thing, what can you get? So I've been talking a lot about patents. Sorry for that side step here. You can also get other types of, and those are generally a lot less expensive than patents. Copyrights, trademarks, trade secrets, and patents are the four most common types of IP for early stage startups. And patents are usually the most expensive. It would be unusual to have a trademark that costs as much as a patent, but I'm sure it happens. Copyright covers things like the words in a book, or a photograph, or a painting, or written computer code. Copyright doesn't cover, for example, the idea behind a painting. A still life of a bunch of oranges and pears painted by another person isn't covered, only covers that specific painting. It doesn't cover the concept of a painting of oranges and pears, right? Trademarks and service marks are intended to represent specific products. So in other words, you could have a trademark of a Rolex watch or a trademark of a GE light bulb. Those are trademarks that are specifically meant to address or identify your product. Trade secrets also can make a big difference in your valuation. There's some steps you can take that are really inexpensive in terms of making your trade secrets more valuable. In other words, documenting. So with my clients, I often try to get them to develop a trade secret policy, right? And a trade secret strategy. They should identify their top trade secrets, the ones they think are most valuable. They should write them down on a one-page piece of paper. They should have a trade secret program in place where only a limited number of people get access to those trade secrets. And when they do, they have to sign a paper saying, yes, I know this is a trade secret. I promise for the rest of my life never to divulge it, blah, blah, blah. But that's that type of trade secret program can really add a lot of value to the portfolio or to the value of a company if it's really documented properly. If you have a trade secrets that you haven't documented, they are very often vaporware, right? They don't add a lot of value. And really, I've seen cases where, thinking of a chemical coating company right now, where their best stuff was all trade secrets. And they were acquired for, again, another substantial amount of money. And most of it was based on those trade secrets. So, but again, and of course, this is my point of view since I'm a patent attorney. Patents generally are the ones people look at most in terms of increasing the valuation of the company, right? So what kind of patents can we get? Okay. Part of the patent strategy is to control the cost of developing patents, and understanding what you can get is really important to that, right? For early stage startup, the most common types of patent applications are provisional applications, non-provisional applications, and design applications. A provisional application expires automatically in 1 year. In order to use the right established by that provisional patent application, the benefit of it has to be claimed in a non-provisional patent application. Non-provisional application is the one that actually will someday hopefully turn into a patent, right? Into a utility patent. A design application is really directed at an ornamental design. Good example is a hub for a car, or the shape of the polycon, the triangular shape of a polycon speakerphone. That's my favorite example. And they can be really valuable. That speakerphone, actually, that triangular shape was litigated by Polycom. That's turned out to be one of their more valuable early patent applications, right? So they got a design patent on that shape. And the reason that was important was that shape looks really nice on a desk. People buy that phone because it looks less clunky than a big square one, or a big one big speakerphone that looked like a flying saucer. So again, that's a good example of patenting the things that your clients like. The shape of the phone made a difference. It also made it work better because the speaker was in the middle, pointed up. I assume everybody knows what a Polycom speakerphone looks like. And then it has some microphones around the edge. Each point of the triangle had a microphone. And that made for really good acoustics for that device. And the alternative was, for example, one of the competitors had a flying saucer shaped phone that looked big and clunky on a desk. So again, the design application related to the design patent they got related to why people were actually buying their product. In terms of strategy, provisional application can be relatively inexpensive. So again, if we're looking at strategy in Europe, early stage startup just starting out, it's very likely that you in your patent tree will talk about doing some provisional, because they can cost close to a fifth or a tenth of the cost of a full non-provisional application. And the reason for doing that is a provisional application can be relatively informal. It can include a what requirements document. A good part of it can be written by the client. In contrast, a non-provisional application is preferably mostly attorney written, right? So you're going to have an attorney who's going to write a 40-page paper for you, and that's a relatively high cost. Okay. That's it. That's next. The one more thing that I want to cover, because it's important, because there's ways that IP can kill your evaluation, right? And it would be wrong of me not to mention those in this case, in this talk. These are things that can kill you. I have a colleague, Roger Royce, who's a great guy, and he has a book called Dead on Arrival. Okay, and this is really an example of how if you don't do your IP right, your company can be literally dead on arrival. Okay, and the top mistakes start with ownership. You have to, in order for the IP and the patents you get to increase the value of your company better own them, right? The company needs to own your invention. And you might be shaking your, of course we own your inventions. Well, maybe not. Did the founders and your co-founders assign their inventions to the company? Is everybody involved in the company, including contractors and so on, bound to assign any inventions that they make to the company? One of my favorite examples is Adobe Form. And it's a good example because everybody uses Adobe Forms, and so you can understand it. Well, that's kind of a cool thing. And that was invented by a sales guy at Adobe. And hopefully Adobe had an agreement with him where he had a duty to assign, hopefully for Adobe, assign his invention to the company. And so everybody that you can get, everybody involved, should have a duty to assign any inventions or other work product they do to the company. And that applies not just to patents, but also to copyright. Another example I'd like to give is if you use Upwork or another third-party service to help design your logo, there's a checkbox on the interface when you hire somebody on Upwork that says, oh, and we own the IP to whatever we get. If that box isn't checked, you might get a logo from somebody in Malaysia, a great logo, and pay, $50 for it, but not have gotten the copyright, right? And years later, that person who still owns the copyright comes back to you, right? So be careful. So the biggest mistake you can make with IP would kill your valuation and the value of your company is ownership. And I have seen cases where a company has, gotten over $10 million in funding, and then they're doing their A round, and one of the investors says, well, wait, where's the assignment from your CTO? Where's his invention assignment agreement? And there wasn't one, right? And that CTO all of a sudden turns around and says, oh, I want half the company, or I'm walking away with my stuff. And that killed the company. So make sure that you own your own IP. There's also an issue with other people's IP. That's why ownership is on this list twice. If you inadvertently or intentionally incorporate other people's intellectual property in your products or services, they can go after you, and that can put your company in litigation, destroy its valuation. Good examples of this are using unlicensed images on your website, having an engineer that decides, oh, I know this open source stuff. I can just grab it and I'll take the week off and uh, put that instead, and it'll look like I've done all this work. Or, I did that same. I built a similar system 2 employers ago, and so I'm just going to grab all that code I used before and put it in and go to Hawaii for a week, right? So, boom, your main product is now contaminated with somebody else's code, and they have a really significant copyright claim against you, right? One that you're going to end up paying on, and that can kill the valuation of the company. Number 3 is waiting too long. You should be starting on your intellectual property just before you start talking to investors, right? Once you have a good idea of your company and why it's going to be successful, that's the time to go ahead and start filing provisional patent applications, right? If you wait too long, other people will get patents before you. There's always competitors. And I have seen cases where people have filed things a couple of weeks apart. Big competitors basically on the same subject matter, just a couple of weeks apart. And so get your filing in as early as possible. We do live in a first to file world, right? Fourth big mistake, not having strategy, right? Patenting the things that engineering thinks is cool, but really is not related to the core features of your product. Patenting things that don't excite sales and marketing people. That's good. The last thing that I often see is understanding the patent. The decision maker, you probably, the CEO, the CTO of the company, really have to get a basic understanding of what a patent coverage covers. And if anybody here wants to write me, and my next slide's going to have my email on. If anybody here wants to email me, I will send you a link to a webinar I give on understanding the patent. And it takes about an hour. And after you get that, you'll kind of have an idea of how to look at a patent, how to read it. Things you might learn is how to tell the difference between a patent and a published application. Okay. How to read a claim. That's really important. What the patent means. What's the difference between a claim and the specification? These are all things that's important for you to know. It's the whole, I'm not going to get into it now. It's a whole hour-long lecture, but that's definitely something that's important for you to do, right? Just one story on this. I often get people coming to me and saying, oh my gosh, I've got the patent. It covers everything that I do. I want to go out and start suing people, blah, blah. And I look at the patent application, and the first claim, the independent first claim, is huge. It's like almost 2 columns long. And I say, oh my gosh, this has so much in it. And the inventor will say to me, yeah, I got it really, it flew through the patent office. there was no objection. I got my patent right away. It's got everything I do in it. And I turned to him and I say, well, to infringe this patent, somebody would actually literally have to do everything you do, right? This is the narrowest patent, even though I told this to the last guy. This is the narrowest patent claim I've ever seen. It only covers everything you do. And if somebody leaves any part of it out, then it's not covered by the patent. So if that was a little confusing, go look at my lecture on understanding the patent. A patent with lots of words, a patent claim with lots of words is really narrow. A patent claim with few words, really broad. Okay. Those are things to remember. All right. So now I'm going to go into the webinar chat. I don't think we have a Q&A here. No, just a chat. Okay. Oh yeah, we do have a Q&A. Okay, cool. Sorry. I'm going to go through now, and I see one question in the chat and one question in the Q&A. I'm going to do the Q&A first. I like Q&A. The question is, are you seeing increased activity by IP-backed institutional funds, i.e. those investing in patent portfolios, revenue share, and royalty-based? Yes. So in the last 15 years, I have seen in the patent marketplace, right? People are owners of patents. There used to be a lot of companies like intellectual ventures whose business model was to bring portfolios of patents together. And sometimes they would buy thousands of patents, right? And then go around and sue everybody. And that still happens, right? Those entities still exist. But what's changed in the last dozen years or so is that there's more interest in financing litigation. And so I have seen, it might just be me, but I've seen a lot more companies, even in the last 6 years, the market for, oh, if you have a patent portfolio that you can show is infringed, uh, your ability to get financing to litigate that is really gotten pretty good. There's a lot of entities now that instead of just collecting the patents, they're actually interested in finance and litigation. And some of these companies, they focus on just patents, but they specialize in, oh, we're going to finance patent litigation because we really understand patents really well. And some of them will focus in certain technology spaces, semiconductors, because they have a great team and they can evaluate probability of succeeding in litigation in some specialty area. So I have seen a lot of investors, and I have had my own portfolios financed to litigation financed, and that can be a pretty good deal. So nowadays, it's possible to get money, especially if you can show substantial infringement of your portfolio. If you don't have infringement, it is harder to sell a patent right now, and the numbers are substantially different. I do know people who are patent brokers who specialize in buying and selling patents. But again, like the first slides of the presentation, it really is in the eyes of the beholder. The number one question is can you show that your patent's being infringed by somebody, right? With deep pockets. And if that's true, then you have patent is much more valuable. I personally like patents that have businesses built around them. And on average, I think that a business is more valuable. Taking patents and increasing the value of a business and selling that business or having some nice exit is more likely and more valuable to benefit the founders and inventors than developing a portfolio and trying to litigate. But there's exceptions to either case. Okay, next question in Q&A. Would you agree that there are funds now that invest in one for growth and two for patent litigation? Do you see these funds being competitors to traditional VCs, et cetera, for experienced founders with key enabling tech and IP. So I don't think of the litigation crowd as being litigation funders. Some of them focus on IP, but some of them will do, they fund litigation, and it might be slip and fall litigation or business litigation. And then, they have one little group that does patents. If you go with somebody in this space, you want to make sure that they have had good, successful funding events in the past in patent, right? You don't want to go with a company necessarily that has a great history of financing personal injury, motorcycle accident litigation, and are trying to get into patent. Okay, so I would go for a few, and there's a few key companies out there that are really good at it. If you write me, I can give you some suggestions. And uh, so let's see. Do you see these funds as being competitors to VCs? No. And the reason is that if you're let me just backtrack a little. If you're a startup and you have a patent portfolio and you go after a competitor, by startup, I mean a cash limited early stage startup, right? Before your B or C round. Patent litigation costs millions of dollars, right? I've seen budgets from, 1.5 to 5 million for doing a patent litigation. And so if you're a startup and you get into patent litigation, right, you try to clobber your competitors with patents, it's such a time and money drag that pretty much you become a patent enforcement entity. It's hard to be both a startup company and a patent enforcement company because of the cost, right? And again, maybe you can get litigation on, the other factor is that if you're an early stage startup, usually it takes a while before your patents are issuing about the time you're doing your A or B round, or, often near your exit. So, if you sell to a big company, you exit to a big company that has deep pockets, they're the ones who are more likely to uh, monetize or to enforce your patents. The reason I don't see VCs as competitors because VCs are looking for um, growing companies. They want to see companies that grow and have a profitable exit, right? Hopefully a unicorn type exit, where you grow the company and then it goes public, great, or is bought by a big deep pocket acquirer. That's what the VCs are looking. They're looking for that type of exit. So they're a pretty different crowd than the we're going to buy on patent litigation crowd. Their exit plan is a lot different. Patent litigation crowd doesn't want you to spend time on building a company. They want a reward through litigation. They want to be able to sue a deep pocket company for patent infringement and get a big royalty out of it. So that's their exit plan. And they are not really, those are very different business strategies. And I don't think I've seen a lot of cases where you have a VC. I mean, the VC would like to get your IP. If company crashes, the VC would like to end up with your IP and be able to sell it or give it to somebody who will litigate it. But they don't generally, I mean, that's part of the equity that they want to keep, have of the company. So part of their security interest in the company, but they are not usually looking for that. It's a different group of people. Okay, so I think I answered most of the questions under the Q&A, and in the chat there is a question. Okay, is there ever a reason to copyright a letters patent? Typically not. I mean, there can be some issues. I have had patent applications that were that included that got in trouble with Copyright Act, specifically because a patent application included decryption technology and like had a figure with decryption code in it. And the DMCA, the code was publishing the code was a violation of the DMCA, the Digital Millennium Copyright Act, because it explained how to decrypt certain encrypted DVDs. And the patent office did everything they could to clobber that, to kill that patent. But if you log in to the patent office website and know to look up that patent application number, you can actually find that code. Um, uh, but yeah, you not typical to copyright a patent application. The copyright really covers a different set of things. Um, okay, I have a last slide here. And again, if anybody reaches out to me, there we go, last slide. Yay. If anybody reaches out to me next day or so, I would be happy to send them the link to my presentation on how to understand patent application. This is my email and my LinkedIn. Please feel free to connect with me on LinkedIn. Ramon Law is an international law firm. I think we're only in 11 countries now. We dropped to Russia, for instance. But we are a semi-virtual law firm, so we're very different than a typical law firm. We have about 5 times more partners than associates, so we're kind of upside down. Most of the partners have 25 plus years experience. And because we're semi-virtual, our ops tend to be really small, a couple of conference rooms and maybe 1 or 2 offices shared by attorneys. Most of us work at home, and the law firm is over 15 years old. We've always done that. So we have a really low overhead. We have a much better rate. Most of the people at Ramon, most of the partners came from the big law firm, right? They were charging thousands of dollars an hour at big name law, and they came to Ramon. They can charge less, but make more money because our overhead is so good. So that's it. Please reach out to me if you have any further questions. Thank you, Jennifer and ProVentures, again for hosting this event. I really appreciate it. Have a good day. Thank you very much.